Hello, good evening, everyone. Okay, thank you for tuning in to Property Zone Live tonight. I'm Shawnee here, as usual. I'm the moderator for session tonight, and we are very honored. Okay, we actually have the opportunity to invite Casey Lee, all the
Hi.
way from East Malaysia. Okay, now let me do a bit of introduction about the topic today, as well as his background. Casey, basically, I knew him for decades. Okay, he's basically a licensed financial advisor representative, and he also have a lot of extensive legal knowledge and as well as personal knowledge, extensive knowledge, very resourceful about integrated estate planning. To be honest, when you talk about integrated estate planning, it's more than just writing a will. I think later Casey will share a bit more about this. And the reason that I actually promised to wanted to do a session today is because, as you know, for the last 18 months, not just in Malaysia, but the whole worldwide, we have been looking at numbers. The number of people contracted COVID-19, the number of people, unfortunately, lost a battle to COVID-19. It actually ring a bell. It create a lot of awareness to us how fragile human life is. At 1 minute, you could be healthy, alive, spending wonderful time with family and your loved one, but the next moment, you could be unconscious in the hospital, in the ICU with intubation. So what happened? You never have a chance to say anything to your loved one. And what happened to your estate, to the asset, to the legacy you want to leave behind to your next of kin, to your family member? So I think it's very crucial that we actually wanted to start the conversation. And of course, we are very honored to get some wonderful input from Casey. Now, without further ado, after this brief introduction, I want to kickstart the session uh, for today live session. The first question I want to ask Casey, okay? But Casey, because the first question it will be, he mentioned to me, it's going to be quite extensive. Actually, he prepared some slide, okay? So the question number one would be like a summarized 101 lesson, okay? For people who want to know a bit about estate planning, okay, from groundwork. Okay, without further ado, I'm just gonna start with question number one while waiting Casey to share the slide. Okay, Casey, how you know? How will the property, as specifically, but also in general about the estate, how can people pass to their next of kin uh, when unfortunate events when they pass away? Can you share with us about this? You will be able to share your screen?
Sure. Thanks, Sean, for inviting me. Like you mentioned, for question one, I'd like to present a background legal process that everybody will get involved when they passes on. Okay, anyone see the screen now?
Yeah, but is the screen has you? I think you're sharing the entire screen. Yes, I think you can
Okay,
just.
all right. Thank
That's
you.
great. Okay.
Okay, so just give me the opportunity to give you an overview. So when a person drop off, so all the assets will be frozen in general. Then what happens is that usually you got two situations. So a person can drop off without a will, or the person have a will. Okay, so these are very general. So when a person dies without a will, then they'll have to apply for letter administration. If it's in West Malaysia and in Sabah, then they have to go to apply for this letter administration in the High Court if the gross estate is above 2 million ringgit. Okay, if it's below 2 million, then you go to what we call the small estate administration process, where you can go to the land administrator if there is a property. If there's no property, just only liquid cash and investment, then can go to this Amanah Raya. Okay. On the right hand side, we recommend people to have your own planning with at least a will. If a person died with a valid will, then the next of kin or the executor appointed in the will go and apply for this what we call the grant of probate. Okay. So on the left hand side, when a person died without a will, then the the legal block will be more serious, because in this Probate Administration Act applied to West Malaysia and Sabah, then you need to have surety, means two guarantors together with an administration bond equal to the value of the deceased estate. So this is the heavy stuff that you have to go through if you don't plan with a will. Okay, so for people especially in West Malaysia and Sabah, you must have a will. In Sarawak, because our law is a bit different, we follow the state law here. We don't go to High Court. We just go to our public probate office. Okay, so in this whether in this letter administration or this kind of probate, you will have to appoint a person called a representative. Okay, usually I put it this way: a person die or cease the existence in this world, so then you need a representative to step into your shoes to continue doing your job. Okay, for example, your assets, including your property, all are under your name already. But you're no more in this world, then somebody have to step into your shoes and continue the work. So what happened is this representative, if it's under left-hand side, it's called administrator, or this one is executor, then they have to look for your assets and then inform all the creditors and pay off the expenses, including the unpaid income tax. And secured creditors are like, for example, your mortgages that you get it from the bank, okay, where your property is charged or mortgaged to the bank. Then you have to settle it off before the property can be discharged and then given or distributed to your beneficiaries. Okay, so once the executor or the administrator pay all the expenses, then only then you can distribute the net estate to the beneficiaries. Okay, for beneficiaries, so beneficiary, if you have a will, then you will would have listed them down in your will. A person die without a will, then they will follow Distribution Act 1958, which I'll give you some detail. And if you are Muslim, then you follow the Faraid, which I'll also give you a little bit of detail afterwards. So just bear with me a bit of details. So we just mentioned a bit more about the Distribution Act 1958, amended in 1997. And this act says that if a person die without a will, then who will be able to inherit? Okay, and this law actually apply in Peninsular Malaysia and also in Sarawak. For our friends in Sabah, then you follow your Tested Ordinance 1960, which only apply to the state of Sabah. Okay. All right. So for Distribution Act, just a quick one. Let's say this is me, easier to visualize over the internet. And then I dies, and then I left behind a father, 80 years old, a wife, and 3 children. So what does the Distribution Act says when I don't have a valid will? Then the government has a will for me. It says that the assets actually is entire estate, but I use a house to illustrate. Okay, so for example, you invest in properties and all these things. So just take one of the properties, then you'll be divided in such a way where my wife or my widow will get 1/4, my children will get half. And after 1997 amendment of the Distribution Act, it complicates the matter a bit more, where my surviving parent, okay, in this case, my father inherits 1/4. Okay, but the complication is that if let's say your assets involve only mainly like cash or liquid assets, then it's easier to split, But when you have properties, I know Malaysians love investing in properties, so you may have acquired multiple properties. So you have to be careful, because if you don't do your specify in your will, then under Distribution Act, then the administrator will have a headache trying to split the ownerships of properties. If the beneficiaries cannot agree among themselves, then you have to have joint names in all your properties. Okay, so this is the complication. And to complicate the matters further, my father already very old, and assuming that after he inherit this 1/4, after this 1/4 of this undivided share of this property is given to him under his name, after subsequently he passes on, he dies, then the next question is, this 1/4 of this property, who will inherit? Okay, when we follow the Distribution Act, then it will follow in such a way that when my fathers die, then no other beneficiary except children, they're given to children. Okay, so from my point of view is to my own brother and sister. Yep. But from my wife, my widow point of view is the brother and sister-in-law. Okay, so this becomes a very complicated. Yeah. And of course, other assets, we have not looked at it, but most of them are liquid assets, so less of an issue. Right, so this one, I just tell you a story. I was in Penang many years ago, and then my colleagues were driving me around Penang Island, And then when I saw this bungalow, I said, stop your car. I want to take a photo of that. He said, why? I said, oh, I want to take a photo so the next time when I conduct estate planning talk, I can always share with my my audiences, You see this one very interesting. So you go and use this to sort of like cut the bungalow into half or whatever. So a house or property you have your land title. You cannot just cut it like so. You join them. So you join them, then you have complications. Okay, so this one is just to talk about the Distribution Act, who dies, leaving behind who, and who will inherit. This one you can just Google it on your own, or you can just print screen. All right, so just a little bit more. Without a valid will under the Distribution Act, certain categories of beneficiaries are not recognized. Okay, so this one is partner, means don't have a marriage cert, and illegitimate children means children outside the marriage, also not recognized. Stepchildren not recognized, so they cannot inherit. All your other dependents or age relative, they will not inherit unless you provide them inside your will. Okay, and for our Muslim friends, it's a bit more complicated, but I just show you the core, what I call the core group. Okay, let's say example, you just picture, I am a Muslim, so I dies. Then my father, I'm Muslim, so my Muslim father always get 1/6. My Muslim mother always get 1/6. If don't have father and mother surviving, then this 1/6 will be either inherited by my son, if I have a son. If I don't have a son, then this balance will go to my brother and sister. Okay, I'm a Muslim man. Then my widow will inherit 1/8. All right, and for the rest will be going to children, but they have certain rules for under the Islamic distribution law of faraid. If I only have daughters, then the daughters will inherit 2/3 of the balance, and then the extra balance, so-called the residue, will go to my brother and sister. But if I have a son, then all this balance will be inherited by the son. Then my brother and sister will not come into the picture. Okay, so this is very brief description of inheritance under the faraid distribution. Okay, so this one is a bit complicated because, but just give you an overview, just for you to appreciate that in Malaysia, because we are comprised of 3 regions, because when we formed Malaysia in in 1963, of course, after that, 1965, Singapore left. So now in Peninsular Malaysia, like I mentioned just now, the probate law means the process of applying for legal papers. You use the Probate Administration Act, which require you to go to a high court, and also in Sabah, also have to go to high court. Okay, and in Sarawak, because we are under our ordinance, so we just go to our estate, this probate officer in each of the divisions in Sarawak. And then the other one is law of distribution. When a person dies without a valid will, then you already know just now already, in Peninsular Malaysia, we use Distribution Act. And in Sarawak, a person die without will, also follow the Distribution Act, like what I mentioned just now. In Sabah, they follow their ordinance. Okay, and for Muslim in all these 3 regions, we follow the faraid, like what I mentioned just now. All right, so just very quickly, just to share a few tips about how do you do your estate planning, so to avoid all this legal hassle and also delay, along the way. So of course, the basic one is will. So very quickly, just a few points. So when you have your valid will, the most important thing is you can actually administer or distribute asset according to your wishes. And the most important also, you can appoint your own executor. Like I mentioned, a person dies, then you must have a representative in this physical world to represent you. And then your executor will execute your instruction and your wishes in the will. And for those people who have minor children, then you can appoint your guardian for your minor children in this same document called the will. Okay? And just try to impress upon your mind that who can be an executor, and actually you need a person who is very experienced. So here I put a cartoon here, a very experienced Superman, so a very competent person who do your job. All right. So his job or her job is to locate your will and to apply for the process of grant of probate in the High Court. And then he has to identify your list of assets and list of liabilities, including for property owners like yourself. then you have to make sure that you need to cancel off your outstanding mortgage loan before it can be distributed. Okay, and then right. So this one, just to say that this person died in 1898, leaving a will to provide monthly payments to widow and children. And the balance of the estate worth $1 million at that time to be managed by a trust to benefit the descendants about 100 years after his death. Okay, you've probably heard of will, you've probably heard of trust. Let me just explain very briefly in the next few minutes just to appreciate what is this trust all about. Okay, so how to use your trust? Basically, trust you can divide into two types. One is what we call a testamentary trust, means you actually set up this trust inside your will. Okay, let me just repeat. So you can set up a testamentary trust inside the same document called a will. Okay, of course, this one you require a competent estate planner or lawyer or will writer to advise you. Okay, then the other one is just to let you know, you can also set up a living trust. Living trust basically means while you are still living, you can set up a trust, who is like actually a legal vehicle that can hold your assets. Okay, and the advantage of this living trust is that it will not be frozen when a person dies. Unlike in a will, you still have to go through a ground probate after all the things are frozen. Of course, these are a bit more detailed things, but just to let you know that there is such a thing, and then you can actually seek more information from competent advisors in that sense.
Sorry, can
Okay,
you
so
just for a moment?
Sure.
Okay. I just wonder when you mentioned about the testamentary trust.
Yes.
And also the living trust. Which category does the insurance trust fall under?
Okay, usually popularly, now the market, a lot of insurance agents promote this insurance trust. Basically, what it means is that they are using a living trust. Okay, by what we call the trust deed is actually a legal document, and then your existing life insurance policy or your insurance agent will analyze your insurance needs. When you need more additional insurance, then they recommend you to take out a new policy. Then you can actually absolutely assign into this living trust. So it's a very good advantage when because after a person dies, then this living trust or insurance trust will not be frozen together like your other estate and all your properties. Usually for this insurance trust, usually you do it with a trust company. So the trust company will be the appointed trustee for this living trust, and they will actually collect the proceeds from the insurance company. They'll file in the death claim, and then the proceeds of the insurance policy will go and fund this insurance trust. And inside this insurance trust, you can customize some of the points. For example, you can customize your beneficiaries. Usually you use it to provide, provide for minor children, for example, or other categories of beneficiaries. And then you can even specify investment policies for investment of the money and all this stuff. Okay. And then if you have this living trust, since it will not be, what do you call that? Frozen, and also the insurance money inside this living trust does not form part of the estate of the deceased, then it will not be subject to the estate creditor's claim. So there are certain benefits for this kind of structure or products. But it's good to get proper advice from some competent guys, so that you get well advised and you get a better pictures from there. Yeah, thanks for the question, Sean. Let me just a few more slides, then we are done for the question one. Okay, so a trust can be provided to provide, for example, monthly maintenance income for surviving widow and children. Like just now, the guy from this who died in 1898 in Singapore. So this one, he actually put inside this trust, inside his will. So the technical word we call is a testamentary trust. So you can, for example, this one is in Chinese. Actually, he put a lot of his things inside the testamentary trust, including his properties, which has rental income, and also shares. We have dividends, he doesn't want to distribute straight away to all his beneficiary, so you can put inside this kind of testamentary trust to ask the trustee to hold on trust for him, and then the dividends and the rental income can be given to the surviving widow and children or even grandchildren. Okay, so it depends on how we would like to structure it. Okay, so much about the technical stuff and also my slides. So let me get back to our conversation. Yeah, Sean. Okay,
Yeah,
so my screen.
So from now on, I think there will be enough At least a technical point to share about from the slide lah. Okay.
Yes.
So I think coming to learn from what it has happened about the things that they will share. Maybe just let me just summarize it from a property buyer or property investor point of view. A lot of times when we buy property, I look at it from the front doorway and the back doorway. The front doorway is actually when we buy a property, we always look at, for example, rental yield. For example, expected return on our investment, how much it can go up every year, how good is the location. We actually do a lot of analysis on the front door approach. But the bungalow, become the expensive asset, a property like a bungalow in prime area, just become a total waste just because the distribution part, the estate planning part did not actually, was not taken care of. So I think to complete the pictures of a successful and also a smart property investor, not only you need to take care of the front door by doing the analysis when you want to buy a property, I think it's quite crucial. So we take care of the back door so that whatever we have done in our lifetime do not goes to waste, and it deceives the purpose that we want to buy a property and provide for our next generation or even next generation. So I think with the COVID, it actually trigger more awareness on this. I think your sharing just now it can't come in a better timing. So the second question, let's zoom into property it specifically. Let's say if a person has a property with or without loan, or in a technical term, whether it's encumbrance or unencumbrance, does it make any difference in the process of distribution?
Oh, definitely. Okay, you see, like Sean, you say two situations. So left-hand side, we just say, okay, with encumbrances, or of course, a lot of time we use OPM, other people's money, all right? So we borrow the money from the bank, financing and this kind of thing. So what happens is that you all know better that you have to charge your property to the bank. Yeah, and then until you finish your loan repayment, all this, then you have to go and get a discharge, isn't it? You take back your property, so-called, only then it's under your name. So so when a person dies, let's say I buy a property and then I use this kind of method, financing. So if when I die, then my representative just now, if I have a will, then the executor will come in. If I die without a will, then the administrator will come in, most likely my spouse, my wife, then comes in. But it's not as simple, no? You have to go to the bank. Okay, normally the bank, they are quite practical. As long as somebody continue to service the repayment, the loan is not, overdue, not default, then they are quite okay, right? So the problem comes when person don't have enough cash flow to continue service the loan. Then they will have to. The worst case scenario is they have to go and lay long, go and auction all the property. So if let's say like you can settle the loan, okay, that's why the life insurance come in very importantly. Then you can actually cover the whole amount, outstanding amount, or most of it. Okay, let's say all of it, then pay off already. Then the executor or the representative will go and get the discharge. So the one have to employ or engage a lawyer to all this paperwork. Okay, once it take back already, means discharge already. Under my, I died, so it's under my estate. Then my representative, for example, my executor, then will have to do another step. All right. So of course, the law firm will know how to do. Then you have to transmit the property from this person's name, or C. Marty, to the executor or the administrator. All right. This is called transmission. After that, then only then transfer to the beneficiary, either based on just now, person died without will, follow Distribution Act, or follow, if I have a will, then follow my wishes, for my terms inside the will. So if you have loan, then this is a whole process that you need to be aware of. Then, of course, the other one, if so-called clean property, no loan, nothing, then of course it's quite straightforward. It's under my name, and then we have to do the transmission. Then you do the transfer to the beneficiary.
Okay, that's great, straightforward. Okay, let me just pause here for a while. For thank you for tuning in, Sui Chia. Okay, Nicholas is actually our colleagues. We're actually taking care also of property zone, but in the Mandarin session. Ruben from East Malaysia also. It's actually a taiko and seafood in terms of land matter. In fact, I just had my free consultation from him this afternoon in regarding some land matters. Okay, so for the audience, while you're watching here, if you have some questions in regards to whether it's a will or whether in terms of living trust or in terms of the whole estate planning, when I say estate planning at the moment, no, sometimes the whole estate planning is more than just which asset I should give to who by what percentage. Although this is a crucial one, but this is not the complete picture of the integrated estate planning. So I think the awareness is getting more important nowadays. So without further ado, I'm just going to go to question number 3. I think the question number 3 is, how should I say, is very unique because a lot of times we will realize the mistake we make in life and we improve and we get better from the mistake we make. But when we come to estate planning, if you make a certain mistake in your estate planning, probably there's no way for you to rectify the situation because, like Casey said, you are ceased from existence in the physical world. How are you going to come back? Are you going to go through some of the BOMO, to talk to your better half or surviving beneficiary? I think it's quite unlikely. So we can't learn from our own mistake in terms of estate planning. But Casey, can you share with us through your experience some of the mistake people have made, or sometimes some of the things people mistake not necessarily is an act of commitment, but the mistake can be also referred the act of omission. There's something that you do not do, but is actually form part of the mistake in your life. It could be also form part of the mistake in your estate planning for not doing something. So can you share with us what are common mistake people actually do or actually did not do in terms of estate planning?
Okay, that one actually the question is quite wide. Actually, I can write a book on that. It's a quick one. Okay, put it this way. A lot of people never spend enough mental energy to go and think about what they want to do with wealth, including properties and other assets that they have accumulated so far. Actually, this morning I was talking to one business owner introduced by my friend, and when he gave me the information, he gave me actually a flow chart. Okay, he's actually the second generation eldest son, and then his father is still around, and then they have accumulated. There's a family business. Okay, then when he gave me the list, I got a shock. They have all the properties. Okay, so under the senior guy, he has properties, and then he has properties in Senyam Berhad. Under him, also he has some properties. Some are joint name, some are single name. Okay, so just to summarize the whole thing about what your question just now is, a lot of people, they never expected they would be gone. Because when gone, I always tell stories. You play mahjong with Steve Jobs upstairs already, and then you don't give no instruction or not enough instruction, just a simple will. Then you have problem. And then the biggest problem, because although you go and play mahjong with Steve Jobs, his iPhone also cannot code down to this physical world. So the only way is I always make a joke, you have to, in Chinese, it's called tuok mong, okay, dream. Then the guy upstairs, the guy downstairs, either is the executor with a simple will, or the administrator also have a tough time trying to guess what is it that you want. I do okay, my father, I thought he, kind of problem. So he also cannot call up also. So that is the biggest issue. Okay, so you put it very correctly when in asset planning, you can't even learn from your own mistake. By the time you make a mistake already, you are already not in this world already. So you learn from other people's mistake. Okay, so of course a bit more detail depend on how much asset you have and this kind of thing, your complexity. So it's better to spend some mental energy. So I always advise my clients to think through it. Sometimes it's not very pleasant. I have people who have this kind of thinking, like this morning he said he wanted to just get a lawyer to write a simple will. Simple will means I got 5 children, I'll give them in certain percentage and that's it. Then I tell him that, okay, if you have a simple estate, you get 1 house, 1 car, 2 banks account, 2 insurance policy. They want nothing much lah. I got 5 children. Then of course, you have certain percentage of equal share. But you have more assets than your children or your beneficiary. Then it's better for you to go and think through. And this morning when I talked to him, actually it struck him, this idea. Because he's a Christian, I said, okay, you see, just imagine on Christmas Day, you leave behind what they call that, a huge bag of presents inside. He said he got 5 children. So I said, okay, let's say you got eight presents inside the bag, the Christmas bag, goodies bag, and then you just give it to the 5 children. Do you think they can just decide among themselves which present to collect? Okay, exactly the same. Okay, for people who invest a lot, property is a good investment, long-term investment. You appreciate in value and things like this. So it's get more, right? So you got all these multiple properties. And I have another client some years ago. He gave me 2 foolscap paper. One foolscap under his name. Another foolscap under the wife's name. All the properties and land that I accumulated now. Okay, so like I say, if you have this kind of in this kind of situation, if you just write a simple will, it will not solve your problem. You just delay the problem. Okay, like I mentioned, if you have 8 items in the goodie bag and then you give to your 5 children, I doubt they can do very well in terms of identifying who gets what, isn't it? So since you are the owner of these assets, then it is the onus upon you to have some mindfulness and also we call wisdom to think through how you want to give to them. So after I talk like this to some of my other clients, then they go back and talk to their wife, and then they come back to me. They say, okay, this asset, okay, my eldest son, I think I'll give him this piece of land. Because this guy is more entrepreneur. Maybe he can develop this piece of land next time. Oh, my second one, this one professional, just doctor, for example. I just happy with his work. This one I just give this this one. So you think like that. And just a few weeks ago, I got another one. Very interesting. He had 3 children. First one is an engineer. Second one is daughter architect. Third one is also an engineer. First one doctor. Second one architect. Third one engineer. So engineer is working in his company. So this one is a good situation whereby the second generation, because he's in contract work and all these things. So he got multiple assets I mentioned just now. So I get him to go and think through it, then at least come back to me. And then this is called estate planning, more than just having a simple will and, so difficult to think how to give it to them. Just write simple will and that's it. But like I mentioned, it will not solve the problem. You just delay the problem until towards the end, I think the end result will not be what the person would like to have.
Yeah, take note of your feedback. Okay, just let me share a little bit thing. Actually, Casey is my mentor. Okay, the mentor in terms of estate planning more than 15 years ago. Okay, of course I ventured into property and he continue on to give advice and consultations to people in terms of estate. So he's in this case a long-term mentor. And I always remember one thing he shared with me. I think it applies to many people, regardless how old are you. Okay, did understand this? Okay, that happens to any people at any age. Okay, you may seem that it's so far away, but regardless where you are, as long as you can understand about the topic, I think there's one thing I think we should share among ourselves is that they are probably in different stage of life. For some people in stage of life is that they haven't even thought about what to give to who. The simple mindset is not even, the mind map is not even developed. But the second type of people, they have actually come across something in their mind, even between husband and wife, but they don't talk to each other. They have these simple things, but they won't talk to each other. They don't even write down and put into action. And third will be the people, they actually wanted to do something about estate planning. They thought about writing a will, so on and so forth. But when it comes to listing down all the documents, they find it very troublesome. So to be honest, if you find that reorganizing, finding the asset that belongs to you is troublesome, you will know that if you're gone one day without giving specific instruction, your beneficiary, your family member, your loved one will have 3 or even 5 times more trouble, more challenge compared to you, who happens to be the owner, who knows everything and whereabouts of your asset. So if you find challenge, if you find like procrastination in doing this thing, I advise you not to, because it will only create, not only delay, but it actually magnify the problems to the loved one. And sometimes it create disharmony, not knowing who is getting what, right? So I think there's a very important point. Next one, okay, I think I will just skip to the gist of the questions. The question is, when it comes to property in specific, okay, some people even, okay, the senior people that I know, especially through this COVID-19, that actually thought about, shall I just straight away give the property to my children, even though I'm around, versus another option. I put the property inside my will as part of my estate planning so that my children will still get the property or get whatever asset, in this case, the property, uh, in the event I pass us on. So how do you weigh the pro and cons? Okay. So I mean, actually, we are going to the question number 5.
Sure,
We
sure.
are skipping the MLTA. So I think, how do you weigh transfer to our children immediately, or you know what, put in my will, part of my
Okay,
estate
just
plan?
share a bit of experience. Some seniors, that this are thinking, oh yeah, about time that I should sort of like think through my things, then I sort of like give to my children, then my job is done. So some people will think, okay, then of course they'll say, okay lah, I transfer out. But you transfer out, of course, the hassle is of course the legal fee and others. But my advice to all these seniors is always you just put inside your will. Okay, number one is very cost effective. Secondly, most important, all these assets, property, all these are still under your name, so you are still in control. Okay, so what is a will? Okay, in Chinese we call it 圣旨, means emperor scroll. It's just that, okay, I put all my instruction in here, then it's just on standby. Okay, you follow the Wills Act, the specification of validity of a will, then a proper witness, all this just on standby. When you are around, all the property is still under your name. You are still in control. Okay, that's very important, isn't it? Then secondly, this one is just, like I say, standby. If you change your mind, you can just write a new will. Okay, maybe 1,000-2,000 ringgit, few hundred ringgit, so that's it. So it's very efficient. That is the first point. Because once you transfer out to your children, not saying no good. I'm not saying that your children are no good. Actually, your children are good because they are trained by you. I always like to be a bit more cheeky, it depends on the other half of your children or your future other half of your children. Yeah, both people we have, like Sean, now my children are teenager. Later on, they are already adult after graduate, all these things. Then parents being parent, you start to worry about other things already. About who is the boyfriend, who is the girlfriend. Do they love my boy or do they love my properties? All right. So these are additional things that you think through. So it's better to just keep it in your name. Just write your will, then just on standby. And the other thing, I always when I advise clients who are with adult children, means they are already so-called more senior. Think about things for yourself, especially the house that you and your spouse stay together. For the last 30, 40, 50 years. So what you do is that you better give it to your spouse. Statistically, men die faster than women. Means women live longer than men. Statistics. So I always look at this as well. And recently, actually, I advised one couple. Actually, it's a very simple case. They only have one house. They have 5 children. So one day I got a call from the daughter. So he said, hey, my father wants to write a will and he has one house. He want to give the house to all the 5 children. Can we write like that? He said, can. But I always make a point that, okay, I visit, although it's COVID-19 with full this SOP, I visit the house, and then the senior is having cancer already. Then I look at the wife. The wife is much younger than him, so still very active, healthy. So I say, Ken, if you want me to write like that, I can write. I can follow the wishes. But let me give you my point of view, and then see whether you can take into consideration. So this man retired, of course, and then with wife, 5 children, nice, beautiful family. So now that house, the man, the old man, and the old woman used to stay together, and so what I advise is, since the house is under the name of the old man, I say you give to your spouse first, give to your wife. Okay, then your wife also write a will, then give to the, we can write substitute right to the children. So I do in such a way that I have two wills, one for the old man and then the other one for the women. So the old man will write the will, this house I give to my beloved wife. If my beloved wife predeceases me, then I give to my 5 children. Okay, and also get the wife to write the will to say that my house, this is an in aspect of inheritance, even though the house is not under the wife's name. So because the old man already has cancer, this is my assumption. Probably you go off first. Then the wife inherits the house. Then in this will, in the lady's will, I say this house give to 5 children. So in that case, I can cover the whole situation. One person die or 2 person die, then their intention is still being captured into that, right? Because I don't want to see when a man dies and then the widow suddenly, sleep with this man for last 30, 40, 50 years, suddenly found that there's no security. Okay, of course, I mentioned just now, children are okay, but the complication is the other half. Okay, like that. Then the danger is that the wives, the poor lady may find that at the end of the day, he doesn't have a house, a roof over her head. I think the worst tragedy that can happen to a family. Okay, so I just share this kind of funny stories for you to think about.
Yeah, it sounds like funny. It sounds like how should I say? It sounds like a movie, but in actual life, it does happen. It does
Yeah.
happen. I think it's from your own personal experience.
Mm.
So actually, for those of you who are still with us, actually today when I invited Casey, I said, don't worry, it's only about 20 minutes session. But he poured it all out, he shared with us not only his extensive knowledge in terms of estate planning, also share a lot of life experience. The situation, the question, the problems, the challenge his client face. I'm not sure if you have another 5 minutes to maybe explain the next questions about MRTA and MRTA. You okay with that? Maybe we can complete
Yeah,
that.
sure. Okay, just a quick
Okay.
one. MRTA stand for Mortgage Reducing Term Assurance. Very simple is usually you buy from the bank, but make sure that you get the bankers to make sure that you have this MRTA for you, insuring your own life. If you are the borrower, if you are joint borrower, then depend on who is the main person paying the housing loan repayment. So if the husband is the main person paying the loan, then better to have a full amount on the main payer. Although sometimes the bank says, okay, we can split half. I also got cases recently that the lady says that, my husband is paying the loan, but MRTA is on myself. I say, why? Because the premium is lower, because I'm younger. Okay, that is a consideration. But in terms of asset planning, financial planning, you must know who is the person who is paying the loan. So you cover the main person, not the main breadwinner in that sense. Okay. So the other thing about MRTA, it is good. Okay. A lot of contrary to a lot of insurance guys, some say that don't take MRTA, take MLTA, mortgage level term assurance, where the sum assured will not drop, or take a personal insurance policy. My investment link can cover you for whole life kind of thing. Irrespective of all those things, MRTA still have very important advantage. Okay, because you only pay one time, because single premium. Okay, even though sometimes in planning, I also advise people even let you can even build into the loan. Okay, your person you have not very consistent or reliable income, up and down. Then sometimes it's better off you just take the MRTA, even the premium built into the loan, because only one premium, so there is no renewal debt. So this policy will never lapse. Because I seen in a paper some years ago, it's really a sad story. The man have an insurance policy, but it's an annual premium type. And then the premium is of course paid by through credit card or bank account deduction. And then it came to the paper because it is a news story. Because when this man died, then the widow went to the bank and said, hey, I want to cancel all this loan because of insurance and all this thing on my husband's life. Then when they check, very sad. They say, oh, sorry, your life policy lapsed. Huh? Why? Because the accounts, the bank could not deduct the premium. So the premium were not received by the insurance company. That's why it lapsed. How sad, isn't it? So sometimes it has this kind of advantage also. So that's why I give you this kind of information. Be mindful. Even though you get input from the sellers or promoters of this insurance product, but also think through what is your needs. All right. So of course, if your cash flow is stable, kind of thing, then you may want to have may consider life policy. We have level premium or level coverage. Sometimes can be increasing coverage, but be mindful that these are annual premium policy. You have to keep paying the premium. So this is briefly what I can advise to clients when they ask me this question.
Okay. Okay. Thank you so much. You spend more time as we agree upon. That's fine and generous of you. So the last part I want to see, just in case of people, sometimes as you know, audience when it comes to this sensitive topics, they want to seek further advice from you. I think there are two questions they want to ask from you. How come? First, in regards of estate planning, and perhaps the other thing they want to find out is how come you still look so young, even though I did mention that you're my seafood. I don't want to reveal your age, but how come you look younger than me, even though you're my seafood? So there could be two things they want to ask you more about. So how can they get in touch with you, or what are things they can search in Facebook or whatever?
Okay. Actually, I have come up with a website where I have some write-up for people who are in different situations, whether they are parents with young children, adult children, individual in complicated family relationship, or childless couple, or business owner with assets. So you can just go to my website called estateplanningmalaysia.com.
Estateplanningmalaysia.com.
Holding up, yeah. Or you can search my name, Lee Ki Chuan, and then you just type will writing or you type estate planning. Then I also have some articles that came out which I've written in, like for example, Free Malaysia Today. I'm still writing for them, so you can actually search for it. In my website, then we have this. You get my contact information, or you can just click a button. Then I have a WhatsApp button kind of thing.
Yeah. Estateplanningmalaysia.com. Okay. Yeah. So I think pretty much we have covered all the things we need to cover for tonight. Again, thank you very much, and also maybe say a good night to the audience.
Thanks a lot again, Sean, and also your company for inviting me. We have a lot of more things to share. Actually, half an hour is not enough. So okay, so I think we with this 1 hour, I think we can get some of the message across to our friends. All right, thanks a lot, Sean. So we keep in touch again. All right, thank you.
Okay,
Good night. Bye bye.
Bye bye.